Hello and welcome to another episode of Family in Scope. On this program, we discuss issues affecting women, celebrating their wins and seeking ways to solve their challenges. I am Amanda Ezekwe. Recently, for the first time, there have been a focus on changing social trends in the institution of marriage in Nigeria. In 2016, there was a publication stating that divorce is uncommon in Nigeria. 0.2% of men and 0.3% of women have legally gone through divorce. Unfortunately, the situation with the number of divorce cases in Nigeria has significantly increased over the past few years. The total number of divorces in Nigeria cannot be compared to those in the United States and European countries. The current statistics shows a negative trend that has formed in a short period. Currently in Nigeria, it has been discovered that most divorce cases have not been favorable to women for many reasons, which we'll be discussing. My guest for today is a lawyer, mediator, gender rights advocate, and public speaker. She actively promotes advocacy for the enforcement of the VAP Act and other women and child rights laws. You'll get to meet my guest after the break. Stay tuned. Welcome back. My guest today is Chioma Onyenucheya, lawyer, mediator, gender rights advocate, and public speaker. She actively promotes advocacy for the enforcement of the Violence Against Persons Prohibition, VAP Act, and other women and child rights laws. A committed and active member of the International Federation of Women Lawyers, FIDA, popularly known as the Zest Family Lawyer. She is the principal legal consultant of Zest Legal Consult, a law firm in Abuja, Nigeria. You're welcome, ma'am.
Thank you very much for having me.
Good to have you here.
The pleasure is mine.
You know, today we're talking about divorce, the legal rights of a woman. First of all, what are the types of marriages in Nigeria? Let's start from there.
Okay, essentially, the types of marriages we have in Nigeria would be customary marriage, which is marriage under native law and custom, and one of which would also be Sharia, marriage under Islamic law. And then, of course, marriage under the statutory marriage. So any of these are the types of marriage people can engage in. So it's either the marriage is happening under the native law and custom of the parties, or under the Sharia law, or under the Act. So these are the types of marriage.
So all these are the types of marriages. Now let's come to divorce. What is divorce?
Well, I'm sure we will agree that a marriage is a contract, some sort of civil contract between two parties.
So what is divorce?
Okay, so marriage being a contract between two parties, or the number of parties who are involved in that marriage. Divorce will then be the dissolution of the contract of marriage. So where parties for reasons, any reasons, feel they can no longer continue to live together, can no longer remain in the marriage union, they can ask to go their separate ways. That is what a divorce is. And it is a final dissolution of a marriage.
So final, that there is no coming together anymore, like final?
Yes, final. And the reason I make that emphasis is because there is also a thing called judicial separation. So there may be times where parties feel things are falling apart, they can no longer tolerate each other, or it's safest for both of them to go their separate ways. They can actually go for what we call a judicial separation, but it is not a final dissolution. It is simply a judicial pronouncement, an order of court, that enables them live separately. They may lead separate lives while remaining married to each other. Do you understand? So the difference between that and a divorce is that in the case of a divorce, it is a final separation.
Okay. Like
Yes.
you took me to my next questions. Like
Okay.
the type of divorce. You mentioned the judicial one and the normal final, or do we have other
No.
kinds of
We won't
divorce?
even say types of divorce.
Okay.
There is really only one kind of divorce.
Okay.
And once you call it a divorce, it is a final it's a dissolution, it's a final separation. Do you understand?
Yes.
But there are other forms of separation which will not amount to a divorce. So a judicial separation will not amount to a divorce, but it will also amount to a separation, except that it's a temporary separation, except where parties feel we would rather things remain like this, and then they approach the court to convert it to a divorce proper.
Okay, we've seen a situation where people will say that the first 5 years of marriage, if you can survive it, then you can survive the marriage. Through your practice as a family lawyer,
Yes.
what particular year or which particular year do you have the highest rate of divorce?
Okay, I cannot claim to have done a deliberate data analysis to be able to say that it is this exact year. But I've seen that most of the divorce I've handled and those I've observed would usually happen between maybe the second, third year of marriage and about the 15th, 16th, 17th year of marriage.
That long?
Yes, that long. In fact, my personal experience, maybe because of some of our the constraints in the law permitting parties to divorce at younger ages of the marriage. So I find that most of them are between 5 and 17, most of them. And then you have a larger cluster of that number, under 10 years.
So what are the causes of divorce most times?
The prominent causes for me are domestic violence. Okay. And when I say domestic violence, I want us to also understand that domestic violence is not just about physical abuse. Do you understand? So you find them in different forms, whether they're economic, whether they're verbal, psychological, emotional. Do you understand? Any of these forms of abuse are some of the things I see.
Can you explain more on this?
Okay, why I mention that is because oftentimes when you mention violence, people think it has to be physical before it's violence. But under the VAP Act and by other relevant laws in Nigeria, violence has gone beyond just being physical. We know the concept of violence has been expounded rightfully beyond just physical. You have forms of violence where, for example, when we were having a conversation earlier, you mentioned gaslighting. Yes. That's violence. That's psychological violence. Do you understand? Where you manipulate a person to the point where you subjugate that person. The person feels he or she cannot live without you. He or she, cannot take a decision or a step without, you keep making the person feel inadequate, lose self-confidence because of the things the party in the relationship says or does. Do you understand? Where some of them even get to the point where they're beginning to doubt their sanity and doubt their competence and their capacities, all of those. Then it could also be economical. One of the things I see around economic violence is that, and unfortunately women are mostly the victims, you find women whose husbands or, partners will not allow them earn a living or will not even allow them explore their choices of career or vocation. Do you understand? And then you see other forms of violence where maybe abandonment, spousal or abandonment of children, and then maybe things like restriction from having relationships or maintaining relationships with family and friends. All of those are forms of violence. And those are the kind of things, one of the kind of things that I see that learned people to say, I've had it up to here and I can't deal further. I would rather out. Then the other thing I say would be where, infidelity comes in. Now, or in cases of infidelity, I do not see a lot of women opt out on the grounds of infidelity, except where it degenerates to the point where maybe there are venereal diseases being introduced into in the home, or where there is now a child out of that of indiscretion. So that's one of the grounds. Then, of course, things around maybe religious manipulations or family interference, or drug addiction and alcoholic, excessive alcoholic consumption. So sometimes people, I've had a number of people who allege that their partners are getting addicted to substances or that they are drunks. And rightfully, it's one of the permitted ingredients that you can satisfy the court with to show that the person is of such intolerable behavior that you cannot reasonably be expected to continue to live with him or her. So those are some of the things I see as reasons. And then, importantly, the other thing would be where there is either withdrawal of consortium between the parties, or where it is of such nature that one party begins to feel deprived, like not quite satisfied. That's one of
it's actually
it's a thing, a very serious thing. In fact, there's been situations where you find that, couple who live together haven't had intimacy at all in more than 4 years or 5 years, and they just maintain appearances before the public. Some of them attend the same church or the same religious places. Some of them do things together that make it appear that they're still a couple in the true sense of the word. But when either of them now approaches you to brief you on their situation, you realize that they've been maintaining separate rooms, they've been leading separate lives, there is no intimacy between them, and sometimes for as long as 5 years or more.
Recently, do you think women are the ones who initiate divorce? They have become a voice of their own and go ahead to do it.
Okay, so before now, there used to be some sort of stigma attached to one being called a divorcee. So a lot of women tolerated abusive situations or less than satisfactory situations. But there is some sort of paradigm shift. So women are beginning to come into their own. And in situations where they think that the relationship is not quite yielding the satisfaction they desire to yield, many more women are, taking the bull by the horn and boldly asking out. So yes, there is a growing number of women who are saying no.
When divorce is initiated, what are the rules that has to be kept within that period until the hearing?
Well, as with every matter before the court, once a matter goes to court, parties need to maintain status quo. I'll explain. Mm-hmm. It's a popular, it's a popular expression, yes. Okay. So what that simply means is that because you have brought a subject to the court to determine, to decide, you cannot take steps that will overreach the outcome of that matter. For example, where there are properties or there is a property in issue, maybe as to who retains ownership of the property or who keeps the children and things like that, any of the parties who tampers with those subjects that have been brought before the court to determine will be overreaching the court, and it will be contemptuous. Do you understand? So one of the things that need to happen is that all the issues that the court need to be resolved, that the court needs to resolve, parties need to maintain things the way they are. They shouldn't tamper with those things. If there are accounts, don't go pulling all the monies in the accounts, like you just go and pull everything so that they no longer find the money there. Or maybe if there are children, don't go absconding with those children because the court is still trying to decide which of the parties would have physical custody of the children. If there is a property that has already been listed, don't go selling it off and things like that. Do you understand? Then again, parties need to maintain, modest comportment in their relationship with the other party. Some of the things, if that doesn't quite happen, a party may offend the other, maybe by the things they say or the things they do, and some of those things may still be used against them. Do you understand? Maybe to validate assertions that have been made before, in the processes filed before the court. So if, for example, during the period of divorce, one party sends abusive messages to the other, calling the other all sorts of names and threatening the other, that is not quite right, because the other party can also say, my lord, even during the pendency of this suit, look at what the other party sent to me, which further confirms what I had told the court, that he's abusive or she's violent. Do you understand?
Yes.
So parties need to maintain decorum while their lawyers, represent them in handling, sorting out whatever their issues are before the court.
We know that women are, like you said, more likely to institute a divorce case because they are...
No. I didn't say that.
Okay.
I said that more women are beginning to. But that's not to say that women are more likely. Okay. We also have a number of men who will just say, no, I've had it. So, but what has happened is that before now, it would usually be the men alleging, just saying I don't want any more. But now we have more women who are also saying,
I'm done.
I'm done.
So, like, they come out and say it.
Of course, they come out and say it. And then, one of the things that used to happen would be that a man feels entitled that because maybe he's the one that pays the rent or he's the one that has built a family home, that he could just evict the woman out of the home and that rests it. But if it is a marriage under the statute, if it's a statutory marriage, the proper thing would be to go back to court, to go to the court and obtain a dissolution from the court. Nobody can take the laws into his or her hands by evicting a spouse or even other dependents from the home. That's also an act of violence.
That is a crime on its own.
Yes, it's a crime. It's listed as forms of violence under the VAP Act, whether it is a man or a woman. And one of the interesting things is that when we talk about this violence, many men think women are just crying foul. They do not realize that anybody can be a victim of violence. One of the interesting cases I handled was a woman who actually evicted her husband from the home because she's the one that built the family home. And she thought that because she built it, she had a right to send the man packing. And she got her brothers who bounced the guy out of the house. Do you understand? So if we realize that power dynamics are gradually shifting, because many women are also beginning to earn the way men used to traditionally earn.
And empower themselves.
Exactly. So what it means is that any party who has the advantage of power, the balance in his or her favor, can actually abuse the other per time, depending on the kind, the form of violence. Do you understand? So when we say eviction, it will be erroneous for anybody to think eviction is only a man evicting a woman. Whether it is a man or a woman, it will be an abuse and a crime for one party to evict the other, including evicting children from the home. The law does not permit that.
Now let's come to the custody of the children. You just mentioned children.
Okay.
Who gets the custody of the children and on what condition?
Okay. The court's focus when you talk about children is whatever serves the best interest of the child. The court is not particularly interested in the parties. The court does not award custody of children as a compensation to one party or as a punishment against another party. No. The court simply awards custody of a child on who serves the best interest and welfare of that child. So some of the things the court will look at is between the parties, which of them has better relationship with the children, which of them will better be available to nurture the children and supervise them appropriately, which of them is willing and has shown willingness over time to do that, which of them has the means and all of those. Which of them is of wholesome character to be a good example for children. So those are the kind of things the court will look at. The court will not look at sentimental issues like, I'm the one that carried the child for 9 months, or I'm the one that has been paying the child's school fees from day one. Do you understand? So even if you're the one paying the child's school fees, if all you do is be an absentee parent that sends money to pay a child's fees, you can as well pay the fees while the other party retains physical custody of the child. So what the court is interested in and of paramount consideration is what serves the best interest of the child.
How long does it take for a separated couple to get divorced?
So when you say a separated couple, that means that parties are already living apart. And under our laws, if they've lived apart for about 1 year, and the party who is instituting the divorce petition is able to convince the court that it was the other party that caused the separation or is the reason why they've been apart for 1 year, or where they've been apart for 2 years and, both of them are, neither of them is opposed to a divorce, or where they've been apart for 3 years. You saw the three, In any of these situations, they can approach the court for divorce. And when they do, well, because the wheels of justice grind slowly in Nigeria, and also because our courts are minded to helping preserve the family, unit, they will not quickly grant a divorce. They would still delve into a hearing to ensure that they extract sufficient evidence to satisfy themselves that these people, exactly, that it is safest or that it is better for the two of them to be granted the divorce they seek, or either of them to be granted the divorce they seek. Once the court has so satisfied itself, then the court will make that pronouncement. But for that finding to happen, parties must still adduce evidence. Do you understand? So the hearing would usually start with maybe, sometimes they'll say, mention the matter. After you've mentioned, they confirm that parties have exchanged pleadings and all of those, and then slate for hearing. So it may take between, maybe, I haven't done any matter that was resolved under 4 months, but I'm saying between 4 months and maybe 2 years would be an average.
Have you ever handled a divorce case knowing that there were signs from the early years of the marriage or even before the marriage that would eventually lead to a divorce?
Many. And unfortunately, most times people do not realize that by our law, one of the grounds on which you can be deprived a petition for denied, an application for divorce, a petition for divorce will be what we call condonation. So condonation means you have condoned this act.
Over the years.
So if, for example, a man beats a woman, or if a woman has slept with another man, and then the other party comes to say, she slept with my best friend the year we got married, and I can no longer tolerate it. I want to divorce her now. The law says you have condoned it. And whatever you have condoned, the law perceives that you are forgiven. And if you have forgiven it, you cannot turn around. You can't appropriate and reprobate at once. You can't forgive and still come back to cite the same thing. But what may happen, which I see happen oftentimes, is that though the signs were there, and though there are previous, infractions or previous offenses, and those offenses have been forgiven, where there is a reoccurrence, a party can actually hinge their intolerance or their anger. They can hinge it on the reoccurrence. So the mention of previous episodes would just be to say, though I had forgiven previously, I see that it doesn't make sense forgiving this particular one because the ones I forgave before, I was promised it won't reoccur. But for this to reoccur means it's needless continuing to forgive. So what I'm saying in essence is that, yes, oftentimes you see that there were red flags and sometimes pink flags, but people believe that,
What do you mean by pink flags?
so those signs that are not so glaring, subtle signs that we make excuses for. So if, for example, a couple goes out for a date, and then the guy or the woman loses her temper at the waiter, the party may think, he has never lost his cool with me. This waiter must have really done something for him to lose his cool with her. So she may not think that it is a flag that will affect her. She thinks it's subtle. It doesn't look like he will be aggressive against her. It was just against somebody else. You understand? So pink flags are those signs that are not as pronounced as what we term the red flags. But red flags are obvious signs that people should heed and be guided. But unfortunately, we're very religious people. We're very optimistic people. We make excuses for everything. We believe that, with God, all things are possible. God can change him. No, something must have, he didn't mean to do it, and all those kind of excuses. So, and nobody is perfect, all of those things we say to ourselves to convince ourselves to tolerate, forgive me, nonsense. So,
okay, let's come to the Marriage Act in terms of property.
Okay.
The Marriage Act of 1990, Chapter 218. The married woman under the Act enjoys equal rights to the family assets acquired during the marriage, and to be involved in their disposal during or after the marriage or upon the death of her spouse. Does this actually work in Nigeria?
Sure, it does work. It does work. So I had spoken earlier about some of the things parties need to be careful about during the process of a divorce, and had mentioned including tampering with maybe a property. So what it means is that if it was a given that a woman will not be entitled to the proceeds of a property or to the enjoyment of a property, there will be no need to say don't tamper with it. But there may be times where the court will either award the enjoyment of that property or, co-enjoyment of the property or the proceeds therefrom between the parties. Do you understand? So some of the things the court may look at would include, each party's contributions to the acquisition of that property. And it doesn't necessarily mean that that contribution must be financial. So I'll give you an example. One of the cases I handled, the man acquired the property. But in acquiring the property, the woman was taking care of the fees of their children. Do you understand? To allow the man some space to, focus in actualizing that, what was a family dream, as it were. So it could be anything. If either of the party has lent support to the other in ensuring that a property is acquired, or generally helped the home while another did acquire it, the court would not perceive it as a property privately owned by the other, regardless whose name is on the title document. And then again, the court may also look at the duration of the marriage. So even where a woman has not contributed at all to the acquisition of a property, but she has given most of her life to the marriage, it would be unfair to treat her as, she's not a passerby. She was a stakeholder in that union. So she's rightfully entitled to the proceeds of the things that has been acquired in the course of that union. So those are some of the things the court will look at in determining who they award the property to.
Let's look at the family.
Okay.
Two people are involved in a divorce case.
Okay.
How does the extended family affect them positive and negatively?
Okay, even before you get to the point of divorce, one of the things I've said as some of the reasons I've seen why people land in a divorce situation is also interference from family and friends. So we find that because of the extended family system in Nigeria or in Africa, it's difficult to expect two people to just relate within the marriage union without consideration for other family members, including parents, siblings, and sometimes maybe stepchildren, and all such other people. So what happens, just the same way those people can interfere in the enjoyment of that marriage during the pendency of the marriage, when the marriage degenerates to a situation of divorce, you would still find that some of those people may, influence things. One of the ways they can influence things would also be to either frustrate a possible resolution of the issues. Because the fact that a party or parties have approached the court for divorce does not necessarily mean that divorce must happen. One of the things the law impresses on counsel to do, and which the court also makes effort to do, is to encourage parties to explore settlement. There are times when a divorce petition has been brought to court. In the course of exploring settlement, since the party has already brought a petition, the facts on which the petition is brought become obvious, right? Mm-hmm. There may be things the other party didn't realize were of such serious nature that the other would be moved to ask that the union be dissolved. So the awareness of those facts may be a reason why the other person has a sober reflection to say, oh, I apologize. Okay, I am willing to make XYZ concessions. I am willing to make this and that adjustment. I am willing to, do you understand? Aha. So settlement can actually happen and divorce will be suspended. So, but in the same wise, sometimes the family obstructs, the success or successful attempts at separation. At other times, they may serve as witnesses, which, even if I say so myself, sometimes you find that these are exaggerated witness, exaggerated testimonies. Some people will come and tell tales that are too hard to believe, things that will fuel the atmosphere and the process of divorce. Do you understand? Aha. So, and then again, sometimes they do things that engender animosity, bitterness in the union. I find that it's usually more easy for people to forgive their spouse or their partner for an offense against them than it is for them to forgive them for an offense against their parents or their children, and even sometimes their siblings. So when their relations, their parents or their children get involved, even if they would have willingly forgiven the offenses that are meted against them directly, they find it difficult to forgive the ones that their parents or their relations are unwilling to let go. They feel that they owe some sort of loyalty to their parents to fight the righteous fight and be, justly angry on their behalf and insist. Do you understand? So those kind of interferences actually sometimes make the process quite bitter and, drawn out.
Has there been any situation where the other party refuses to grant a divorce?
It is not for a party to grant a divorce. But yes, there are situations where the other party may oppose the granting of a divorce. It is the court that reserves the right to grant or not grant a divorce. But either party can ask for it or oppose it. But even then, we have also seen awkward situations where one party asks for maybe a judicial separation, like I had mentioned earlier, if you remember, and then the other party, in his or her answer, says, no, I have a counter petition. I do not even want a judicial separation. I want a divorce. Yes, that happens. But then, yes, there are many times where the other party may not want a divorce.
Where is the place of children in all this? We've talked about custody, but if it is a situation where the divorce is very messy, how can the children be taken out of this?
Well, unfortunately, the children cannot be sent away or wished away. Do you understand? They are part and parcel of the marriage and issue. So what would usually happen is that sometimes the courts, in granting custody to one person, may grant access to the other person. Sometimes the court may also grant joint custody and then define who keeps the children when, and when the children reverts to the other party. But there's really no time where you remove the children from the consideration of the issues of divorce. Once there are children involved, they must be considered, because they're not going to, they're not going to float in the air. They, like I said, the court is more interested in their best interest. So if the court feels that their best interest to be served by being with party A during school days and being with party B during vacation, or being with party A while party B visits, or being with party A weekdays and being with the other one weekends, things like that, the court will decide.
We've been discussing divorce, the legal rights of a woman. We'll be going on a short break, and when we come back, we'll delve into other issues that has to do with divorce, affecting the children, affecting the women. Stay tuned, we'll be right back.
We are a nation blessed with people of diverse cultures, religions, languages, and opinions. It is ironic that we are now being ripped apart by our greatest strength, our diversity. We have allowed intolerance, insensitivity, bigotry, and nepotism to blind our vision of the greatness we can achieve working together as one. We may not have the same culture, nor religion, nor language, but we all belong to the same nation by the divine will of God. We did not choose to be Nigerians. Nigeria chose us. This nation is our divine heritage, and if we open our eyes, we would realize that what divides us pales in comparison to what unites us. And by the comparison and conciliation of our differences, we will grow until our differences disappear. Our unity cannot be willed by mere declarations, nor do we get unity by ignoring the questions that beg for answers. We must celebrate our diversity and debate our differences without fracturing our unity. Our strength is not in our numbers, but in our unity, because even the weak become strong when united. Nigeria unite. This message is brought to you by Abuja Broadcasting Corporation, owners and operators of ASO Radio 93.5 FM Abuja, ASO Television Star Times Channel 127, Free TV Channel 507, and UHF Channel 38.
Welcome back. If you're just joining us, this is Feminine Scope. We have been discussing the legal rights of a woman in the case of divorce. We still have our guest in the studio, Chioma Onyenucheya Uko. Have there been any case or situation where children have been called up to testify against the parents or tell the court what has been going on in the home during a divorce case?
Yes, there are such cases. While it is best not to involve the children, so that whatever disharmony doesn't extend to them and the parents. But in reality, there are cases where maybe the other party is denying facts that has been alleged by one party, and they need to confirm some of those facts, particularly if they are facts that affect the children, particularly. So if, for example, in considering a decision on custody of the child, and then one party alleges that the other party is abusive against the children, abusive towards the children, and the other denies it, the court can actually take testimony from the children to confirm whether or not the other party is abusive towards them. The court can also hear from the children who they prefer to be with.
Really?
Yes, the court can hear that. So where there is a contest, it's not quite a subject of age.
Okay.
What the age may influence will be the weight the court would attach to what the child says. Do you understand? Mm-hmm. In fact, ideally, Once the court is in hearing that affects a child, there should be assessors supporting the judge in court. And one of the things assessors will do would also be maybe, will I call it, some sort of psychological evaluation and things like that. So even if the child is young, but the child sounds, intelligent enough as to what he or she is testifying about, the court will take that testimony, but the court will then look at the weight to attach to that testimony. So sometimes children can be called.
We've seen women who have been going through domestic abuse. Sometimes most of them don't even know how to go about things, especially when they want to leave. How can they step out? How can they start to help themselves, even if it's getting separated?
If you ask me, I think that every adult should have a lawyer. We have this erroneous conception that you only need a lawyer when there is trouble or when you need to go to court. Yes, that's the popular perception, but it's an erroneous one. The reason I say it is because having a good lawyer means you avail yourself of sound legal advice. And sound legal advice can actually save you from some consequences that come with some of the mistakes people make. Do you understand? Having said that, what I'm simply saying is that even at the time of considering marriage, a conscious person should consult a lawyer, particularly if you know a family lawyer. The questions you will ask, the answers you are giving, can guide you in the choices you make of a partner, of a spouse. It can also guide you in the steps you take during the pendency of a marriage. And then when things, or if, I'd rather say if, because we're hoping that marriages don't fail.
No,
but if a marriage fails, the best thing is to seek help. Sometimes the reason some women don't step forward is because they are scared. They are ashamed. They don't want to, suffer the shame or a perceived shame that they failed at the marriage. But sometimes it's not the failure of the party who is seeking the divorce. Sometimes things fail despite best efforts. So where a woman has done her bit and her marriage fails, she should realize that the shame is not hers. In fact, there is even no shame, because as with other things in life, other life endeavors, one may fail 1,000,000 times and still pick oneself up. The same applies even in marriage situations. And where that happens, the person should feel free to approach a lawyer, even if the person is not quite sure as to how she wants to proceed. Consulting a lawyer would advise her on the options available to her. The lawyer will be able to x-ray her situation for her and tell her these are the implications or not. One of the things I've realized is that some people think it's okay to just say, I no longer like my spouse, I want out. The law does not permit for that. There's nothing like I no longer like my spouse. We don't have what you call a no-fault divorce in Nigeria. So before a divorce must happen, it must satisfy the ingredients that the law has prescribed. If you cannot situate it within those ingredients, sorry, make further efforts in making that marriage work. That's what our law says. Do you understand? So it must be that maybe you're showing that the other party is drunk and you cannot tolerate it. There is infidelity and you can't tolerate it. The person behaves in such a manner that, no rightful person will think that, reasonable person will think that you can continue to tolerate it. Maybe both of you have been apart for, separated for the period I have mentioned, or there is desertion. Because in cases of desertion, you may see that parties live together, but one has deserted the other. Do you understand? One is no longer living up to their responsibilities to the other. I had mentioned loss of consortium. Yeah. That is one easy example of desertion. So though they may be living in the same house, if you're not allowing intimacy between you and your partner, you are not supporting your partner's emotional, physical, economic, and other needs, you are not, once you withdraw the benefits that a partner is entitled to in marriage for an unreasonable period, that is desertion. So the party must be able to situate their reasons for seeking divorce under these ingredients listed, which will then satisfy the court on the only ground for the grant of a divorce, which is that the marriage has broken down irretrievably. So you cannot come before the court and say we want a no offense, you know. He didn't offend me, but I don't like him again. I just don't want again. Or, I don't know, I just don't like her again. No. If you don't like her, work on yourself. There must be something that has gone wrong. Maybe in the course of therapy, for example, they may realize what it is. Maybe she needs to start having her bath in the evenings, or maybe he needs to, you know, start conducting himself better. You know, there may just be something, and a place of therapy or counseling may help them sort themselves out. Divorce will not be the option in that case. But where the reasons are such that they can be situated within the permissible reasons by the law, then the woman should consult a lawyer, and then a lawyer will guide her on how best to proceed.
We've seen situations where a woman institutes the divorce and she's being threatened by her spouse. How can you handle that?
One of the things that can happen is that, thankfully, by the provisions of the VAP Act, we have what we call a protection order application. And even beyond that, you can bring interim applications before the court when parties are, you know, exploring a divorce from the court. And one of those can be a restraining order against a partner or a party in the matter. So where, for example, there is threat or imminent threat, the party can ask the court to restrain the other person from perpetrating or inflicting or attempting to inflict the suspected threat. Do you understand? Or the suspected abuse. So that can happen, and the court will grant it once the court is satisfied on the, you know, veracity of the assertions made before the court.
You know, in terms of trying to help this couple, sometimes when domestic abuse is involved and they go to the law enforcement agents, most times they tell them it's a family matter, go and settle yourself. Is that right?
Once there is an element of violence in that matter, it can no longer be a family affair. It is no longer a domestic matter between, you know, a private matter between parties. Because every act of violence is not only an offense against the person, it's also an offense against the state. And once there is an allegation of an offense against the state, the law enforcement officers owe a duty to investigate it. And if during investigation they chance upon persuading evidence, then they should proceed with prosecution. So it is not okay to advise parties to, you know, go and settle their matters, because in doing that, the law enforcement agencies will be failing in their primary duty of protecting lives and property. Because sometimes these are situations that may degenerate to death. Do you understand? Mm-hmm. Or even the infliction of grievous bodily harm. So to ensure that peace is kept and that lives are preserved, the best thing would be to investigate and possibly prosecute. And then the practice of asking parties to just go and settle also serves as impetus for future offenders. If, you know, possible offenders see that the law takes its course, chances are that they'll be deterred from attempting some of those acts that are, amount to acts of violence or abuse.
What's the relationship between a traditional marriage and a statutory marriage?
The relationship between them is that they're all marriages. And they're all valid. They're all valid marriage.
Now, there are situations where, of course, you know, from where I come from, once the parties have decided to separate, the bride price is returned. If the other party also, the same people also had the statutory, can the other party remarry knowing that their case is still in court?
So, once a marriage is a marriage, a statutory marriage, neither party can remarry until the court makes a pronouncement dissolving that union. In fact, if the pronouncement is even a judicial separation, neither of them can remarry until the court makes a pronouncement for dissolution of the marriage, which is what we call divorce. That's the only time either of them or both of them can go ahead and remarry. If either of them remarries during the pendency of the, divorce proceedings or during the pendency of the marriage, it amounts to bigamy, and that is offense in our laws. Do you understand?
Yes.
If it is statutory marriage. But of course, under customary marriage, a man is entitled to multiple wives, and then you find smart excuses. Even where a man is caught in infidelity, he can claim that that he was courting the woman for marriage. So you would not be able to quite say that he's unfaithful to his wife, since he's entitled to remarry multiple wives. Do you get? Mm-hmm. So what that means is that in statutory marriages, even after bride price has been returned, the process is still inchoate. Until the process is exhausted, is concluded, neither of them can remarry. And that conclusion will only happen upon the pronouncement of court dissolving the marriage. But if it were a customary marriage, then parties can, of course, go ahead and remarry.
Your final words to women, especially those going through divorce now and are ready to move on.
Well, the first thing I'll say is that having lived with someone or having, built a life with someone, no matter the number of years, is not, dissolving that union is not a walk in the park. It's not an easy experience. There are emotional, consequences and all of those. The first thing would be to advise that woman to be strong. Realize and accept that it's not going to be an easy experience. Then resolve in your heart to forgive yourself if, the situation is occasioned by some of your mistakes, and then also learn to forgive the other person, because bitterness and animosity have a way of, adversely affecting the person nursing it even much more than it affects the other party. And then take a chance at life. Go through it. Ensure you talk to a lawyer. Don't feel like, don't allow anybody stigmatize you or shame you or anything. People fail sometimes. It is okay to fail. So long as you realize, take the lessons from the failure and resolve to try again. And then, of course, life is what it is. When you walk through it, keep up the bright side of life and just accept that sometimes we try and we don't quite get it.
We sincerely appreciate you for taking our time to be with us today. Thank you so much.
Thank you very much. It is my pleasure.
My guest today has been Chioma Onyenucheya, a lawyer, mediator, gender rights advocate, and public speaker. She actively promotes advocacy for the enforcement of the VAPT Act and other women and child rights laws. A committed and active member of the International Federation of Women Lawyers, popularly known as the Zest Family Lawyer. She is the principal legal consultant of Zest Legal Consults, a law firm in Abuja, Nigeria. The Marriage Act of 1990 states that the married woman under the Act enjoys equal rights to the family assets acquired during the marriage and to be involved in the disposal during or after the marriage upon the death of her husband. Nullifying a marriage can happen at the instance of one party declaring the marriage void because of some defects, and this is done by a competent court of law. Divorce happens when there is no compromise in marriage. In most cases, it is not an option, but if the marriage poses a threat to life, separation should be considered first, and if there is no headway, both parties can as well agree to nullify the marriage. That's the much we can take on the program. Until next week, bye-bye.